Welcome to our YouTube channel Applied Forensic Research Sciences. I am Pritha Kundu, a volunteer of AFRS. Today we are going to discuss about cognizable and non-cognizable offenses in forensic science. This presentation contains what is a cognizable offense, procedure followed in case of cognizable offense, cases based on cognizable offenses, what are non-cognizable offenses, general procedure followed in case of non-cognizable offenses, some cases based on non-cognizable offenses, and some differences between the non-cognizable and cognizable offenses. What is a cognizable offense? Cognizable offenses are crimes for which the police makes an arrest without a warrant or prior permission from the court. When an offense committed is serious and heinous in nature and affects the society at a large scale, then it becomes a cognizable offense. Section 2C of CRPC defines the cognizable offenses, and Section 154 of CRPC is related to the criminal law. So, some examples of cognizable offenses are murder, stealing, dowry death, theft, kidnapping, etc. The general procedure followed in case of cognizable offense includes FIR, first information report, then report to magistrate, investigation, search and production of documents, arrest, remand, statement of witness, medical examination, charge sheet, enquiry, trial, judgment, and then punishment. FIR means the information given to the police against a known or unknown person that he has committed the crime. When a cognizable offense is reported, the officer in charge makes reports to the judicial magistrate and appoints himself as the officer in charge. Then investigation of the offense is done under section 468 of CRPC. Then the search and production of the documents is taken place. Then arrest of the person is done. Then the person is sent to remand if after getting a written application from the magistrate and he cannot be taken under remand or police custody for more than 14 days. The statement from the witnesses are taken. The medical examination of the victim is done in case of rape and molestation case. Then the charge sheet is produced after investigation. Then during inquiry, the witness and the evidences are produced in the court and the judge takes the decision during the trial. Then he gives the judgment against the individual who has committed the crime, and then punishment is given to the person. In case of cognizable offense, the punishment period is more than 3 years and can be up to life imprisonment or death penalty. Some cases based on cognizable offenses like DK Basu versus the state of West Bengal in 1996, Lalit Kumari versus Government of UP and Organization, November 12, 2013. Arnesh Kumar versus State of Bihar, 2014. Shrima Devi versus State of UP and three others, September 24, 2018. These are some cases which are considered as cognizable offenses. What are non-cognizable offenses? Non-cognizable offenses are crimes for which the police cannot make an arrest without permission from the court or arrest warrant. The police need to have a valid arrest warrant to arrest in case of non-cognizable offenses. Non-cognizable offenses are less serious in nature than cognizable offenses. The non-cognizable offenses only affects an individual or few individuals and not the society as a whole. Section 2I of CRPC defines the non-cognizable offenses and section 155 of CRPC are related to the civil law. Some examples of non-cognizable offenses are defamation under section 499 of IPC, cheating under section 420 of IPC, public nuisance under section 268 and section 290 of IPC, criminal assault under section 351 of IPC. The procedure followed in case of non-cognizable offences. In case of non-cognizable offences, the police cannot record the first information report, that is FIR. They can take action only when ordered by the magistrate. A complaint is filed directly with a judicial magistrate in case of non-cognizable offense. Then, during investigation, the police is required to prepare several reports and then they are submitted to the magistrate. The officer in charge of the police station is requested to submit the preliminary report to the judicial magistrate. At last, a final report is required to be submitted to the magistrate as per section 173 of the code CRPC. Then, on the basis of the investigation reports, a trial is conducted and the police is ordered by the magistrate to issue an arrest warrant. Only after the court proceedings, that is the trial, the person when convicted can then be arrested by the issue of arrest warrant by the police, not before that, and then the punishment of the person is given. Cases based on non-cognizable offences are Manik Chandra Chaudhary and ORS versus the state, November 28, 1957. State of Maharashtra versus Jayantilal Popatlal Chandrani, February 2, 1979. Om Prakash and ANR versus Union of India and ANR, September 30, 2011. Adesh Kumar Gupta versus CBI, September 2, 2015. Gangadhar Narayan Nayak versus the State of Karnataka, March 21, 2022. Some differences between the cognizable and non-cognizable offences are: cognizable offences are those under which the police can make arrest without arrest warrant, and non-cognizable offences are offences in which the police cannot make arrest without arrest warrant. In cognizable offence, a police officer can investigate the case without magistrate permission. In non-cognizable offences, the police cannot start investigation without permission from the magistrate. Section 154 of CRPC defines the criminal laws related to the cognizable offences, and Section 155 CRPC defines the civil law in case of non-cognizable offences. In cognizable offences, one has to file FIR to make complaint to the magistrate. In non-cognizable offences, the complaint can be made to the magistrate. Cognizable offences includes murder, theft, kidnapping, etc., whereas the non-cognizable offences include forgery, cheating, defamation, etc. The cognizable offences may be bailable or non-bailable depending upon the nature of the offence, whereas the non-cognizable offences are bailable.